that. So welcome to the training. We really appreciate you attending our training. One of the things that we have, as I mentioned, a local work group working on supported decision making, and one of our major goals is to provide information to families, individuals, professionals, circles of support about what are things that we can do to support individuals. That guardianship isn't the only choice, that there are a variety of other things that we can do to support folks. So this is our 4th training in a 10-month training. And as Caitlin mentioned, the other trainings, the first 3 trainings are on our website, and we'll show you at the end of the session today where you can access those. There's some really important information that's being given out. It's not always easy to catch everything first time through. So you'll have those recordings to look through again, or pass along to other folks who have an interest but wasn't able to attend the training. If you know of people who missed this afternoon's training, we'll be repeating this training this evening at 6 p.m. I want to say thank you to our partners. Certainly Oakland Community Health Network is very committed to this effort, but we wouldn't be able to do this training or really reach our goals without the support of Mary Sheehan-Bugard from the Development Disabilities Council, who's been instrumental in helping us get this training together to get our trainers and specific experts on different topics. So really appreciate their commitment to that. And then also Detroit Wayne Integrated Health Network has jumped on board with Kimberly Hoga, and they're helping us also in their county get the word out. They have people who are very interested in this topic. What is supported decision making? What are things that we can do to support folks? So they want to thank them for also helping us get the word out and get information out to other folks within our Southeast Michigan area. All right, next slide. So our presenters today will be Lisa Lapine. She's from the ARC of Macomb County. When she starts her presentation, she can tell you some of her bio and background. And then we also have Scott De Verona from the division director from Student Loan Repayment Division and the MyAble division. So he'll be also talking about MyAble, and he can give some of his bio and background and what makes him an expert on the topic as well. And then Mary Sheehan-Bugard, who I had mentioned, she's also joined us in the training, and if there's particular questions related to what the Development Council is doing or about other trainings, she's available to answer questions as well. So I really appreciate our speakers, our presenters taking time to provide us this really important information. All right, next slide. So Lisa, you're up. So if you could give us a little bit of background about yourself. Why are you an expert on wills and trusts and future planning? And I'm going to turn it over to you. Thanks, Lisa.
Thank you, Vicki. I very much appreciate you inviting me today. I am just a little bit of background, as Vicki mentioned. I am currently the executive director for the ARC of Macomb County. I am also an attorney licensed to practice in the state of Michigan. And over the last 20 or more years, I've been responsible, or I've been helping families create estate plans for their loved ones, most particularly for families who have family members who have special needs. Can you turn the slide, please? So you keep hitting that button and it'll bring up the rest of the, there you go. So in all that time that I've been doing this, this remains the primary question or concern when I meet with a family: who's going to care for my loved one with a disability when I'm gone? And this question is really huge because it's not just about an estate plan. It's about how do I financially plan for the future, but also it has a lot of questions, or it comes connected to a lot of issues regarding staffing support, transportation, things that we do for our family members who need to access the community differently, that we don't always have answers for right off the bat. So part of the things that we do when we do our estate plan is we plan for the legal end of it, but that legal end of it also allows us to access government resources. Next slide, please. When I talk with families and we talk about planning, And if you keep hitting the button for the slides, it'll ding every time it's done putting the information up. We plan for a number of different reasons when we're talking about estate planning. One of those reasons is to make sure that legally, financially, and medically, the choices that we make for ourselves are going to be what our successor trustees or our successor agents follow through on for us. We plan because a lot of us want to leave an inheritance for our family members. For those folks who might need some support in determining where they're going to live, we plan because we want to make sure that we have control over future living arrangements. We plan because we want to make sure that we're still maintaining our eligibility for Social Security, Medicaid, and SSI, that we're getting support services directed based on what is important for our loved ones and for what they need versus what someone else needs. We plan so that we don't have to go to court for a guardian if we prefer to use a less restrictive term like a power of attorney. A very important reason we plan our community advocates. I use this example all the time, but if you think about when you live with a family member who has learned differently, and you're specifically if you're a parent of someone who learns differently, that as that child was born, went to school, became educated, you were educated about special education laws, special education rules, what an IEP is, what the IEP will do for you, what a 504 is. And as your child aged to 14 to 18, you started talking transition services, and people informed you about what a power of attorney could do, we hope. They informed you about what services were available through CMH. They informed you what would happen when someone turned 18. And then when your loved one started using mental health services, they started talking about what does Medicaid pay for, what does it not pay for. You applied for Social Security and you learned how to make your reports each year to the Social Security Administration. And as your kids continued to age, you were able to educate yourself along the way. Sometimes when we do an estate plan, we choose to appoint people to manage money that have never had the experiences that you have had, and they have to learn how to deal with the Social Security Administration, the Department of Health and Human Services, the community mental health, all at once. And that's where our community advocates can come in real handy because they can help educate or guide folks who are learning how to use the system all at once, which can be very overwhelming, to be able to manage supports and services in someone's life. We do planning because we want to review things on a yearly basis. I look back, I don't think anybody can say that our lives are the same as they were in the beginning of 2020. I certainly know I've got 2 kids home right now quarantined. Neither one thankfully have gotten ill, and I'll continue to hope that they don't. But a year ago, I would have never been worried about my children being quarantined. So periodic review, knowing what's happening in someone's life and how it changed in 1 year is imperative when we're deciding how to support someone. And then we want to be able to get support services without an ability to pay, meaning we want to be able to access what's out there and what's available to us in a way that allows us to leverage what the government benefits will be that are available to us with what private pay services can give us, so that we're always surrounding our loved one in a circle that allows them to meet their needs in a financially responsible way. We can turn the slide now. So before we get into really the estate planning piece or wills and trusts, I want to give a little bit of background and why this is so important and why we want to plan based on why we want to do an estate plan and why we want to do it ahead of time in order to control some of the pieces that are involved. When we look at how we support folks, the sources of financial support that we look at to support someone who might live independent of their family but with support services, sometimes parents are helping with that. Sometimes folks are using government benefits. Sometimes we're reliant on earnings that the individual themselves is receiving. And sometimes they receive inheritance or support from other family members if there's not a lot of planning involved ahead of time. Next slide, please. The government programs that we're going to talk about today that lead up to the estate plan piece our supplemental security income, Medicaid, Social Security disability insurance, Medicare. We're going to talk about staffing supports and services by way of contract through your local community mental health and DHS. And this slide alone actually kind of goes back to the whole, why do we want to have community advocates in our life? If you think about it and you've been doing this for a while and you have a loved one who is an adult, you're probably a really good expert in the areas of service from all 6 areas put on that slide. It is so challenging sometimes when we look at how do we support someone who needs support services when we recognize that we're dealing with one federal agency, multiple state agencies, and a possible community agency, that it can be overwhelming to someone who doesn't get the opportunity to learn this along the way, but instead is having it all thrown at them all at once. So if you think back to the first time that you had to manage the system, and then you look back to what you know now, I bet you'll surprise yourself by how much you've learned and really, really think about what an expert you've become as you've supported your loved one. Next slide, please. So the first benefit that we become interested in when our family members turn 18 is supplemental security income. So what's really important about supplemental security income is that this is a benefit that the federal government provides to someone as long as they meet particular criteria. The first issue and the first most important thing is that the person has a disability that qualifies for the service, and that disability impacts their ability to earn what we call substantial gainful activity, which would be measured by a dollar amount, saying that if you earn under this, you are not earning enough to support yourself. It's a needs-based benefit, and that's what the need is. The need is that you have a disability that impacts your ability to work. You can't have more than $2,000 in cash resources or countable resources in order to qualify for this benefit, although there are some resources that you can own that are exempt from being counted. Things that are exempt are, you can own a home and still qualify for SSI. You can own household goods and personal effects, and you can own a vehicle. And one of the things that's really important about those exempt assets, though, is that while you can own many of those things, contributions from others living with you, or contributions from others for you to pay for things or to maintain those items, can count as some support to you. So you need to be careful, even though those are exempt resources, that how you manage those resources remains exempt. And an important concept with SSI is that if you are SSI eligible in Michigan, you are also automatically Medicaid eligible. Next slide. With SSI, we have to be really cautious about how we bring money in and how we manage assets or resources. So remember, when we're an SSI recipient, we're always keeping our bank account or our countable assets or non-exempt assets under the amount of $2,000 to maintain our eligibility. Any cash over that $2,000 amount can take us outside of what Social Security allows us to have. We can also have some struggles if we're getting in-kind support. And what in-kind support is that if there's something that every month someone is helping you pay for or giving you in order to make ends meet, we have to be really cautious that that kind of support doesn't count against our income eligibility for the benefit. SSI and SSDI are benefits that are supposed to be used first for food, clothing, and shelter needs. That means that the reason we get that check is so that we can pay for what we need for food, clothing, and shelter. We're not earning a paycheck to pay for those things, so the SSI is supposed to cover that. When we are an SSI recipient, we're also paying attention to what our earned and our unearned income is. And what that means is that if we're bringing income in, or if we're earning income on an investment, those things can be counted against our eligibility. So we have to be cautious about how that money is coming in and how much is coming in, so we don't impact earnings requirements as well as asset requirements. So SSI can be a bit of a touchy benefit because we have to be careful of all those things. And again, because SSI and Medicaid have the same rules, if we're being cautious about those things for SSI, we should also be cautious about those things for Medicaid. Next slide, please. The next type of benefit I want to talk about before we get into true trust planning and will planning is Social Security disability income. So we talked about SSI, and we said when someone turns 18, they make application to the Social Security Administration, and if that person meets the criteria, they qualify for SSI. If a person is eligible for SSI and they're able to work, they may not collect SSI because they're able to work and they're earning income. So even with having the disabling condition and having resources below $2,000 in assets, if you have income, that would impact your ability to work. If a person works and pays credits into the Social Security system, that person may be eligible for Social Security themselves, or they might be eligible on their parents' work record. So SSI is a benefit that we get because we haven't worked, we haven't been able to earn, we don't have any work credits. Social Security disability is something that we get because either we or our parent has qualified for this benefit by paying into the system. So if you're working right now and collecting a paycheck, you're usually paying into the Social Security system. If you're working and paying into that Social Security system and a situation occurs where you become disabled, you're in a car accident and you're no longer able to work, you suffer a stroke and you're no longer able to work, you can collect Social Security because you paid credits into that system. If you have an adult child with a disability who was able to show that they had a disability prior to the age of 18, continuing through the age of 22, who has not worked or paid into the system, that individual can collect off of his or her parents' work record as long as we can show that the disability existed before the age of 22. What's nice about the Social Security disability income eligibility is that it's an insurance, which means that there's a little bit of a different test to it than there is to SSI. After receiving Social Security, you are eligible for Medicare for 2 years, and there is no asset test to Social Security. There is an earned income restriction, and what that means is, if the government wants you to work if you can work. So if you're able to work and earn enough money to support yourself, then the government's absolutely going to encourage that. But if you're not able to earn enough to support yourself and meet that substantial gainful limit, then you could collect Social Security disability. And even if you're working a little bit, you might collect Social Security. There's no unearned income, which means if you have investments that are earning income, that's not going to impact your eligibility for this benefit. So I just want to recap a little bit. When we have a person who turns 18, if their parents are working, if their parents are working, living, and not disabled themselves, an 18-year-old is going to collect supplemental security income if they meet the criteria of I have a disability, I'm not able to work, and I need some support in order to pay for my food, clothing, and shelter. If that person's collecting SSI and their parents retire, become disabled, and start collecting benefits themselves, or retire and start collecting disability benefits themselves, their adult children with a disability will collect Social Security off of their work record. Again, the nice part about that is from the SSI to the Social Security is that there's no asset test on the Social Security basis, and the Social Security is likely a little bit higher than the SSI was. What's a challenge when you switch to that Social Security disability, though, is that we lose that automatic eligibility for Medicaid and need to reapply for Medicaid. So going back to that asset test, there's no asset test for Social Security. You can't forget that there's always an asset test for Medicaid. And the reason that that issue is such a big deal is that Medicaid eligibility is what gives us access to long-term care supports in Michigan. So accessing your community mental health system or accessing some of the services through the Department of Human Services like adult home help it requires Medicaid eligibility. So although we may go up in income, we still may need that Medicaid if we're a person who requires support to live our lives, like staffing or respite or opportunities to attend a day program. So it is imperative to understand what Medicaid provides as well, because Medicaid provides a lot of the care or support that our family members may need after we're not there to provide that to them. So again, if I'm an SSI recipient, I'm automatically Medicaid eligible. If I'm a Social Security recipient, I will get Medicare in 2 years after my Social Security eligibility, but I may still need that Medicaid and have to apply for it separately if I need those long-term care and supports from community mental health. I see a question has popped up. Let me see if I can see the whole question. Oh, and look, I'm not doing that right. Can someone read me the question that came up by any chance?
Sure,
Absolutely.
Lisa. Oh, go ahead.
I was going to say, sorry. Is there a way to decline SSDI and get SSI instead so someone can qualify for medical?
So the answer to that is no. If that triggering event of SSI to SSDI has occurred because your parent has retired, become disabled, or is collecting themselves, there's no way to decline the disability. However, if you were receiving SSI or Medicaid if you received SSI prior to receiving Social Security, you can receive a waiver for your eligibility for Medicaid. And that's been a tricky wicket for the last couple of years in the mental health system because of some of the changes in funding. If you have a loved one who falls into the category that they never received SSI before SSDI, it can be quite a challenge to get that Medicaid. But if a person received SSI before disability, they can get a waiver to keep that Medicaid in their world. Additionally, some folks are eligible for Medicaid, Freedom to Work Medicaid if they're working. If you have this particular issue and it's impacting you separately, please make sure you keep my phone number and give me a call and we can talk about strategies to see if there's any way to support you differently. Vicki Suter, I see your hand.
Just to be clear, Lisa, so if our loved one turns 18, but the parents are still working, then they are not eligible for SSDI. It's not until the parent is retired or disabled that the loved one would be eligible for SSDI. Is that correct?
Yes, and I'm going to just add one more thing to that, Vicki. Retired and collecting, disabled and collecting.
Oh, collecting.
So it's not just that we got the that we had those two triggering events. It's that because a lot of folks choose to retire at 62, but they don't collect until they're 66.
Okay.
Okay, so kind of keep that in mind. It's the two-tier. I'm doing this thing with this thing. Okay.
Got it. Thank you for that clarification.
Okay.
That's a complicated one.
It is a complicated one, and what's really important about all of those slides is while the funding streams for SSI and Social Security are so important in order to cover our food, clothing, and shelter needs, it's that component of Medicaid that we really want to stick with when we're talking about estate planning, because that's where the rubber hits the road for us when we're doing wills and trusts. A lot of our family members need that extended care that Medicaid covers, and without that eligibility, it's cost prohibitive for us to get that help. So I always start the presentation with these two definitions because that Medicaid piece and knowing where your money is coming from is so very important. And now we're going to slide right into estate planning because we've done so much heavy lifting already. Now we're going to go into the lighter stuff. That's a little tongue in cheek. So if I write a will, my estate avoids probate, and usually I can see everybody's hands pop up and see if they agree with this. But the answer is true or false. If I have a will, my estate avoids probate. That is absolutely false. It depends on how assets are held. I see another question popped up. If someone is over 22 and receives
SSI currently, will he remain on SSI when his parents retire and start to collect?
Not if he became eligible for SSI before 22. Okay. All right. Next slide. Estates can be arranged during lifetime so that no court is involved at the time of death. True or false? True. And I work really hard to make that happen for a lot of my clients. And then finally, the next one. A will is a ticket to probate court. And that is absolutely true. When we write a will, there are assets that must go to probate court when we have a will. Next slide, please. The purpose of probate for us is to change legal title. So when we talk about a will in probate court, why we end up in probate court is if we have an asset like someone's home and there is a joint owner. My husband and I own a house and my husband predeceases me and my name is on the title and now I own the house. If I write a will saying that my house is going to my children, when I pass away, my will tells the court where my property goes, and it says who's going to manage that property, whoever I name to be my personal representative. But in order to get authority to sell that property, my personal representative must go to court and open a probate estate to get authority to do business on behalf of my estate. So for assets that have only one person's name on it, or assets that have no beneficiary designation or pay on death designation that are not held in trust, I do have to go to probate court to change title on those assets. Next slide, please. A lot of folks don't want to go to probate court, so they create different ways to avoid it. One way to avoid probate court is joint tenancy. That means that we create a situation where someone's name is added to an account and that person owns it with me. Pay on death accounts are another way, or beneficiary designations. Beneficiary designations, when a person passes, a beneficiary designation allows the beneficiary to collect the asset without going to probate court. Gifting, we give the money away. We say, gosh, I'd really like to see you live to enjoy this money, so I'm going to gift it to you. And then finally, we can create trusts. Next slide, please. We talk about why not creating using tenancy by the entirety between spouses. One of the challenges with doing this is that that still requires probate upon the second person's passing if you don't make plans after the second person passes. If there's a joint accident, it doesn't allow for any time to plan. So for example, my husband and I are married. I have a tenancy by the entirety. Something happens to him, now it's mine, and I don't plan quickly enough and something happens to me. Or he and I are driving together and something happens to both of us at the same time, now we're in probate court. And the biggest issue about planning is that sometimes it's necessary to plan when someone is grieving, and that's never a good time to plan because our minds are very rarely clear when we're grieving. We're thinking too much about what we lost, not about what we need to do to protect ourselves. Next slide, please. Why not use joint tenancy between parent and child? When you put someone else on your accounts, you're inviting those persons into your life, and even if they're your children, okay? So for example, if I named my son to be on my account with me, and my son goes into the bank, he can take whatever money he wants out of that account because his name is on the account. Assuming he's a good kid, but he's still learning, and he does something where he gets into debt or he gets into trouble or he gets married and it doesn't quite work out, then I'm put in a position of arguing with everybody that that was never meant to be his money. It was just something that I did in order to kind of avoid probate. Next slide, please. So a lot of folks like to plan by using something called a trust. So this is a little bit of a different concept from a will. It's the same as a will where it says if something happens to me, then this is where I want my money to go. And it's same as will because it says if something happens to me, I name Joe to manage my affairs. What's different about a trust from a will is that during my lifetime, I take my assets and I transfer them into the trust. Next slide, please. So if I have if I do a trust with my husband, we both have management control of that trust initially. If something happens to my husband, notice I always make it happen to my husband and not to me. That's probably not very kind to him. But if something happens to my husband, I'm the survivor, I have management. And then when something happens to me, the beneficiaries receive the property from the trust. So the key to a trust is, and I think these slides got a little bit out of order, but when you talk about, when we talk about the purpose of a trust, the best way to explain the trust is if you have this whole pot and you take all of your assets and you say, Lisa Lapine has a bank account and a house, and she has a 401k, and she has a life insurance policy. And the trust is a pot. And I say Lisa Lapine is putting all of her money in the pot of the Lisa Lapine trust. So my bank account becomes part of my trust because I transfer it into by doing a change of name. I change the beneficiary of my life insurance to my trust. I change my house into the name of my trust. If my trust holds that asset, if something happens to me, then my successor trustee can manage that asset by simply stepping up and saying, I'm the successor trustee and I'm in charge. So the next slide, please. So when I go to probate, I'm giving the process by which title to property is transferred to heirs by the court because I had to give that authority to somebody. Next slide, please. But when I fund a trust, because the trust holds the asset, all of those things that I own are placed in the name of the trust. Because the trust holds the asset, the trust never dies. Therefore, we don't have to go to probate court to administer it. The trust itself and the named trustee can transfer those assets to whoever I name after my passing. So again, why is all this important? We're kind of building up to special needs trust, which is the next step. When I fund a trust or when I have a trust, I'm avoiding probate. If I write a will, I go to probate court on assets that are solely owned by an individual without a beneficiary designation. And I need Medicaid because I might need long-term care. All of that is important because it builds up to a special needs trust. Next slide, please. The reason that special needs trusts are so very, very important is that if you pre-plan your estate because you're concerned about how your loved one will be able to receive an asset, we want to make sure that that asset never exceeds $2,000 and it doesn't upset their benefit eligibility. So a question popped up in the corner and
yes,
it
Lisa?
asked me, yep, it asked me if there's a house. Did it say two houses? I can't remember the question now.
If you jointly own a home, can you have separate trust?
You can, but when you have separate trusts, you're typically doing something for tax planning. So I will answer the question simply and say yes, but the question is, what is the purpose of the two trusts? And that might be something someone might want to ask through a phone call or an email later, Mary. So if we have an estate plan and we do a will or a trust and we say, through my will or through my trust, I want to leave money to my loved one who has a disability, and I want to make sure that they keep their Medicaid eligibility. Historically, what we would do is say don't leave them any money at all, because if they get any money in their own name, it upsets their Medicaid eligibility. But the law now allows us to create a special needs trust to receive funds from your estate, either your will or your trust, where that money would be transferred from your estate to the special needs trust, and that money would be held for the benefit of your loved one. And because it's not controlled by your loved one, and because it's not in your loved one's name, it preserves their Medicaid and SSI eligibility. And the answer is the PowerPoint is available after the training. It's a lot of information. I've been doing this now for 20 years, and every time I do the speech, I get a little bit of it differently. So I'm always happy to answer questions, because this is a lot of stuff really fast. And I've even got to speak more quickly because I got to give Scott his time, right? I'd like to take 2.5 hours. Sorry, Scott. But anyway, we want to maintain eligibility for Medicaid and SSI. So when the money transfers from a will or a trust right into the special needs trust, because your loved one never received those monies outright, it's not considered their money from the Social Security Administration's perspective or the Department of Health and Human Services perspective. So they maintain their eligibility for benefits. What a special needs trust allows for is to your loved one to maintain their quality of life, and then it provides for the trustee or someone to act as their advocate and manage money on their behalf so that they can maintain that eligibility for benefits. Next slide, please. Whenever we're talking about a special needs trust of any kind, the components that are really important about a special needs trust is that that trust is meant for the benefit of the person for whom it is written. So if the trust is written for Sue, then the trust is supposed to benefit Sue. It's not supposed to benefit Lisa. The purpose of a special needs trust is that it pays for extra supplemental needs that government benefits don't cover. Remember, government benefits are used to provide for food and shelter from the Social Security perspective. And from the Medicaid perspective, or if you're using mental health services, they may be covering staffing support or adult home help for additional staffing support or food stamps. So the Special Needs Trust is going to protect whatever money is inherited from being counted against eligibility for the benefits the government gives us to help us live our lives. What a Special Needs Trust does is that a trustee who has uncontrolled, unfettered discretion, which means they can do whatever they want with the money as long as they're acting in the best interest of the beneficiary, and they're taking into consideration all the rules and regulations of the state and federal benefits that we're using when they're making distributions or payments out of the trust. So, as the trustee of a Special Needs Trust, I am responsible for making sure that Social Security benefits are used appropriately to pay for food, clothing, and shelter. The Special Needs Trust is for extra or supplemental needs. So if a person is living in their own home and they're paying their own, they're paying rent or they're paying the taxes, and they aren't able to fix the hot water heater, the Special Needs Trust can pay for fixing the hot water heater. If a person is receiving Medicaid benefits and he or she needs a hearing aid, and the hearing aid isn't a covered benefit under Medicaid, the Special Needs Trust can pay for the hearing aid. So the purpose of a Special Needs Trust is to allow us to balance what the state and federal benefits are that are available to us and what they cover. And that trust picks up the extra or supplemental needs that aren't covered by that benefit. And again, the key to it is that no ancillary benefit to anyone else.
Lisa, we have a question in the chat.
Sure.
Janet writes, why is receiving money from a trust any different from the cash help you warned about earlier affecting benefits?
It's not. I'm not suggesting that a special needs trust would give cash help outward to an individual, rather would pay a third party for services or for assistance, which does not count as support to the individual. So for example, when I'm the trustee of a special needs trust, if an individual needs dental work that's not covered by Medicaid, I would pay the dentist directly for the dental work, and that does not impact their benefit. It's a one-time only payment. I'm paying the dentist directly, and it doesn't count against their eligibility. If I took that same amount of money and I gave the cash to the individual, and the individual turned around and paid the dentist, then the cash could potentially impact their benefit. So that's a really great question, and thank you. It's one of the hard parts about doing this on Zoom. I can't see everyone's faces to see if I'm making sense, so I really love the questions. Because sometimes what's perfectly sensical to me isn't making sense isn't coming out the way I think it is in my brain. So again, the trust itself pays payments to third parties, and for those things that are not covered by state or federal benefits, it doesn't impact benefit eligibility. So next slide, please. Why would we create a special needs trust now? Well, one of the most important reasons is that if you first of all, we never know if something's going to happen to us. So why create it now? It's set up, it's ready to receive it's ready to receive an inheritance if something happens to you. So we maintain that eligibility for state and federal benefits. Also, it's available for family members to be able to transfer gifts. So for example, if I'm planning for an adult who has 2 siblings and one of their siblings might like to leave a gift, it could receive money from that sibling. And then finally, if you pre-plan and you do a third-party trust, the money is never considered the individual's, therefore their benefit is never impacted and they're never controlling it. When that person passes, as the parent, you get to choose who inherits when that individual is gone. I did see a question pop up, but I couldn't see the whole question.
Yes, Letitia writes, my experience has been that the consumer's trust is taxed by attorney fees and attorneys are getting more from the trust than the consumer. Is that an anomaly?
Gosh, I hope so. It's not, so they're not technically taxed. If the attorney's doing work, the attorney's being paid for work. So the question is, what work is the attorney still doing? If there's things the attorney is still doing, I can see that they might be charging a fee, but I would hope that that would be more of an anomaly, or in situations where families are choosing other family members to manage the trust. I don't think we see as much of that as we might see if there's a professional trustee or an attorney acting as trustee.
But on the other hand, it does cost you money to set up a trust. It's not.
Absolutely, it costs you money to set up a trust. So yeah. Because I'm trying to be very conscientious of Scott's time, I wanted to, if we could skip to the next 2 slides. I'm going to skip this one only because this talks a little bit about what Scott's going to hit on, and I think that these are other options when we have money that comes into our loved one's name. And we're really talking about, for my presentation, how to keep it out of their name. I'm also going to encourage all family members that are present to write a letter of intent. I write these for my kids and I update them every year with all the information that I think is important about what I think would be the person's life. Okay, so for example, if transportation is a really, really important issue, I would put in my letter of intent that transportation was a priority for my loved one. The letter of intent is like a guide to the trustee about how to manage so that the special needs trust is used in a way that's effective for the individual based on what the parents thought would be useful. If the individual can't communicate, or even if they can communicate their wishes, they can see what their parents were hoping for them. Next slide, please. An important thing about a special needs trust is it can own a house. So if someone were to pass away and leave money to a special needs trust, that trust could purchase a house. And in a really unique way, the individual and his roommates could pay rent to the trust, get support from community mental health paid for by Medicaid, and the trust could assist with paying for those things that community mental health can't pay for, like transportation, the phone, cable, social or recreational opportunities. So there's lots of flexibility in what we can do with a special needs trust. Next slide, please. So why doesn't everyone have one? Well, so not everybody knows about them, number one. Number two, we worry that we're going to lose management and control of our assets. Sometimes it's nice to have a judge involved. You want the judge to be making the decision because maybe family members are arguing with each other or fighting with each other. Sometimes we don't transfer because you have to actually transfer your assets to the trust to make the plan work, and sometimes that becomes overwhelming for clients. And just as the previous question indicated, sometimes affordability becomes an issue. How do we afford it? How do we make it happen? And then sometimes we procrastinate because I don't know about the rest of you, but as a parent, I find myself thinking I'll live forever because no one can take care of my kids like I do, right? So I have a couple questions. Saw a couple questions going back to the question regarding attorney's fees. There are always attorneys who charge, and it can become cost prohibitive. I'd have to take each case by case, but hopefully that's not becoming maybe I'm hoping that's an exception to the rule and not the rule.
Lisa, maybe what will help with that question is who can be the executor of that trust? Does it have to be an attorney, or can
Absolutely not. It can be anyone the family member trusts. So the rule of thumb that I use with my clients is that, you know, pick someone that you trust to know when they don't know. So if Vicki is my family member and I'm setting up a trust for someone and I want to use Vicki as my trustee, I would name Vicki because I know she would ask for help when she needed it. So she would be a good trustee because she's asking for help when she needs it, not thinking she always knows the answer. I see a hand up, but I don't know how to do that.
There is another question, Lisa, and then we'll go to the hand raised.
Sure.
Jean writes, if the individual pays rent to the trust, then is it implied that the trust, I'm sorry, the chat moved there. Then is it implied that the house belongs to the trust?
Yes, in a situation where the individual was paying rent to a trust, or I'm sorry, okay, I wouldn't expect that anybody would be paying rent to a trust if the property wasn't owned by the trust. So yes, it would be implied that the property owns the trust.
Okay. Next question, Lynn asked, does your trustee need to be a U.S. citizen?
And the answer to that is not to my knowledge. My experience has been that people can be outside of the United States and still be trustees. Sometimes we've run into some issues with different brokerage companies about proving who a person is because they are overseas, but I know of no law prohibiting it.
Okay, and then we had somebody with their hand raised.
Yeah, I had a question about the situation where money can be used for vacations and trips, I saw. So
Sure.
Where someone needs assistance in order for that to happen, is a staff person or another family member, is their trip paid through the trust also, or is that prohibited?
So that question has about 700 answers, and it's not particularly easy. From the perspective of the trust itself, that can be considered a benefit to someone. It can be a benefit to someone other than the beneficiary, even though that beneficiary couldn't take that trip without that individual. Okay, so we'd want to be creative about how we were looking at how we might support that. Maybe I pay the cable bill for 10 months in a row to be able to use different monies to pay for the ticket for the individual to go. Okay, I think the harder question is that sometimes providers or the local mental health system will have rules about whether staff can actually receive that kind of support from a family member or a trust. So it's an answer with several layers, and I think it can be a little bit geographically dictated by the rules and regulations of your local CMH and providers as well. I certainly do not write my special needs trusts with any language in them that says I'll pay for anybody else to travel. Yes, the IPOS can help as well. That's true.
I would just add a quick example. So my brother has a trust, and he frequently vacations with different family members, and we support him during those vacations. So, you know, as family members, we don't ask to be reimbursed for any of that. But he is planning a larger vacation. He wants to go after COVID. He wants to go to spring training for the Tigers. He's a Tigers fan. And so that's going to involve somebody, you know, flying to Florida with him eventually in the next couple of years when he's able to do that. And so, you know, it's definitely pulling the whole circle of support together and figuring out how to make that happen. It's likely to not be a family member, to be a staff person. So we're figuring out how to make that work. And again, you know, being person-centered and just, you know, making sure all that information is discussed with the team and that it gets written right into his plan can be helpful.
I saw another question about, since trusts are not typically supervised by anyone, who looks over the trustee's shoulder? And that's another challenge with trusts. Because trusts aren't typically supervised by anyone, they're only people who are, no one's really looking over the trustee's shoulder. So let's say no one's overlooking this trustee's shoulder, but any interested party who is concerned, if they feel that there's mismanagement, can approach the trustee and or file a petition with the probate court to bring it within the court's attention if they feel like mismanagement is occurring. So any interested party certainly can ask questions, and any interested party can bring it forward to a court if they're really feeling that someone's violating. But that goes back to Vicky's question, the conversation we have with Vicky. How do you pick someone? You pick someone you know you can trust. Sometimes I'll encourage people to pick two people so that they're checking each other out. Excuse me. Okay, so I know that we were kind of working on, we need to get Scott up, right? In my family, the trustee and representative.
Is that your last slide?
Yep. I just saw a slide. In my family, the representative payee and the trustee are different, and that's a good way to make sure that you have checks and balances. Excellent suggestion. When you talk about complete estate plan, don't forget you always want to have your powers of attorney, your patient advocates, and pour over wills, and that letter of intent. And again, that letter of intent becomes so important. To go back to Mary's example, one of the ways a letter of intent can help protect your loved one is, I now know Mary's brother loves baseball. If Mary's brother came and said to me, I want to go to the ballet, I might think twice about whether her brother was asking me or whether someone in his life was trying to attempt to get to go to the ballet on her brother's dime. Yes, some trusts do have trust protectors. That's another way to add a level of support or protection if you are concerned that your trustee needs that, or that you're concerned that there might be argument among your trustees. I could talk forever, you guys. I know that, right? Vicky's smiling because she knows it to be true.
That is great information, and certainly, you know, super complicated. So able accounts. Yeah, we still have time for able accounts because the training runs till 1:30. So we're going to say thank you, Lisa. Great job, as always. Really appreciate all that information and all the experience that you bring to the conversation and to the presentation. It was excellent. All right, so our next presenter is Scott De Verona. And Scott, if you could give us a little bio about yourself, tell us why you're an expert about my able accounts, and then Caitlin will get your presentation up.
Sure. Thanks, Vicki, and thank you very much, Lisa, for the handful of plugs you gave me during your presentation. My name is Scott DeVerona. I work for the Michigan Department of Treasury. I am the program director for the Michigan 529 Disability Savings Program. I have been with the program since its inception in the state of Michigan. We were the 5th state in the United States to have an ABLE program, so we're really proud of the fact that we were an early adopter of this program. And today I'm going to talk about the ABLE accounts and its history. How did it come about? Why did it come about? And then I will do a brief demonstration about the Michigan ABLE accounts. As we mentioned, we always, if people have questions, feel free to put them in the chat. I'm monitoring the chat. But one thing I do want to mention before I get underway, everything that you're about to see is available on our website at www.myable.org, including the presentation slides, including webinars where I'm demonstrating or giving this exact same presentation. And our customer service line is available Monday through Friday to assist individuals with the website and enrolling and creating those accounts. I'm going to put that in the chat right now, so it's there, and that way you've got it. And without further ado, we're going to start with the ABLE Act and its history. So in 2014, Congress voted the ABLE Act into law to overwhelming congressional support. In roughly 30 years ago, when the ADA was passed, everybody was concerned with accessibility, ensuring that individuals with disabilities had the ability to get into museums and schools and hospitals and things of that nature. But nobody addressed the second and, to me, the most important part of the ADA, which was allowing individuals with disabilities to become economically self-sufficient. As Lisa mentioned in her presentation, you're limited to $2,000 in assets, which at that limit, it's impossible to become economically self-sufficient. You are literally trapped into relying on others, be it family or government, for your economic self-sufficiency. So what Congress did is they created a new section of IRS code called 529A. It's modeled after the Tuition Savings Incentive Program that authorized a tax advantage savings program just for individuals with disabilities. You must have a disability to open an ABLE account. These accounts enable people to save for the future while protecting eligibility for public benefits. Any earnings in the program grow tax-free as long as the funds are used for qualified disability expenses. Now, one thing the government loves above all things is acronyms, and the acronym you need to know for the ABLE program is QDE, Qualified Disability Expenses. So the number one question that people want to know, what can I do with this money? So we're going to talk a lot about that coming up. Go ahead. So nationally, what's an ABLE account? Well, an ABLE account is nothing more than an investment account or like a bank account, but it's sponsored by the state of Michigan or any individual state. There are 43 programs live in the United States now. The rules are pretty simple. You're limited to one per individual, which means you can't open an account in Virginia and have another open account somewhere else. The account owner is the designated beneficiary, which means the person with the disability owns this account. It belongs to them. It's their money. Regardless of who put the money in the account, regardless of how it's funded, it's their money. Because we have individuals with disabilities who need assistance with their financial transactions, parents, grandparents, spouses, siblings, or powers of attorney can also open accounts and manage accounts on behalf of a disabled individual. We also allow court-appointed guardians and SSA-designated representative payees, including corporate entities, are permitted to open ABLE accounts. The total annual contributions for an ABLE account cannot exceed the federal gift tax limit, which for this calendar year is $15,000. That is subject to annual IRS changes. Additional contributions are allowed for some ABLE beneficiaries up to $12,880. if those individuals have their own source of income. Rollovers from 529 education accounts are allowed, but they are limited to the $15,000 per calendar year limit as well. That provision does stop in 2025 unless Congress does something to extend that. ABLE assets are excluded from Medicaid eligibility. So like Lisa was talking about earlier, the number of people who are concerned about losing their Medicaid eligibility, you don't have to worry about that with ABLE accounts any longer because ABLE assets are excluded from those Medicaid eligibility checks. You don't have to worry about spending down anymore. You can put the money in an ABLE account and not worry about losing eligibility. That includes any program that Medicaid administers. So any of the waiver programs, any of the other types of Medicaid eligible programs like Children's Special Healthcare Services, home and community-based waiver, any of those programs. Medicaid does reserve the right to claw back, that's their word, not mine, any money that is left in an ABLE account after the beneficiary passes away. Now, Michigan Medicaid has never made a claim to a MyABLE account, but the law allows them to in those situations where the beneficiary passes away. So Janet has a question, what would happen to the money in the 529 if it can't be rolled over? I'm not really sure what that means. The money can be rolled over from a 529 education into a 529 ABLE account. And then I'm going to talk to you in a couple slides about what the money can be used for once it's in an ABLE account. ABLE accounts, or excuse me, ABLE assets over $100,000 do count as a resource for SSI. So once your ABLE account reaches 6 figures, it does change the income that SSI will provide. They will no longer send that monthly benefit check. Doesn't change eligibility, but it does suspend your payments. Again, at $15,000 per calendar year, it's going to take a number of years to get to that $100,000, but that will impact your income potentially if you reach that limit. After 2025, your guess is as good as mine, Janet. Whether they will extend it to allow rollovers, I don't know. When the ABLE program first came out, they did not allow rollovers from education accounts. Currently, they do allow rollovers from education accounts. After 2025, I don't know. They may not. I don't know what Congress is going to do about that. One thing I want to mention while I'm on this slide, ABLE accounts are an asset shelter, not an income shelter. So if your income is impacting your benefit amount, an ABLE account will not solve that problem. If your assets are impacting your benefits, then this is a solution for that problem. Go ahead. Who's eligible to open an ABLE 529 account? Anyone who became disabled prior to age 26. It does not matter how old you are today. I have beneficiaries in my program that are in their 70s, but they became disabled before age 26. You can't have an ABLE account open anywhere else. As I mentioned earlier, you're limited to one. There are 3 ways that you can prove eligibility. You can be eligible for SSI or SSDI due to a disability. You can have a condition listed on the Social Security Administration Compassionate Allowances list, or you can self-certify with a doctor's note. Now, there is an asterisk next to that age 26. Congress, actually this current Congress, has proposed Senate Bill 331 and House Resolution 1219 to increase the age of onset from 26 to 46. Because when Congress limited this to people who become disabled prior to age 26, they left out individuals who become disabled after age 26, people who develop ALS, Lou Gehrig's disease, multiple sclerosis, sometimes happens after age 26. People who are in accidents that cause traumatic brain injuries, sometimes after age 26. And those people cannot avail themselves of this program currently. Congress realizes the short-sightedness of that, and they have proposed to raise the age from 26 to 46. It hasn't happened yet. I hope it will, but trying to predict what Congress will do is next to impossible. Go ahead to the next one. What can ABLE assets be used for? As I mentioned earlier, they must be used for qualified disability expenses. The IRS defines qualified disability expenses as costs related to the beneficiary's disability or blindness. They must be used for the benefit of the beneficiary. Like Lisa mentioned with trust assets, you can't withdraw money and give it away to somebody else as a gift. It has to be used for the person with the disability. Tracking of QDE is a responsibility of the beneficiary, the person who owns the account, or their authorized representative, whether that's a parent, sibling, guardian, power of attorney, rep payee, whoever is helping them with the account. Because disability expenses are subject to audit by the IRS and the Social Security Administration, To my knowledge, no My Able beneficiary has been audited yet, but that is simply a function of it being such a new account. It's going to happen. I just don't know what the IRS is going to be looking for. But if you have any concerns over whether what you're using is eligible, here's the best way to find out. If you go to the next slide, the IRS provided a specific list of all the things that you can use your qualified ABLE account for. QDE is meant to be as broad as possible and includes the expenses of everyday living. So just like you can use your 529 education account to pay for tuition and books and fees and the cost of education, you can pay for those things out of an ABLE account as well. You can also pay for housing, rent, mortgage, utilities, garbage removal service, internet service fees, any form of housing costs you can use to pay for you can use your ABLE account to pay for. You can also pay for transportation, whether that's a bus pass or a vehicle or an Uber or a flight. You can pay for any transportation costs out of an ABLE account. You can pay for any healthcare costs or medical costs, whether that's a piece of durable medical equipment or pharmacy costs or the costs of laboratory and x-rays or just visiting the doctor, to pay your copay. You can pay for those out of an ABLE account. Letitia writes, would it include a home modification such as a lift or a ramp? Absolutely. Any modifications to a home to allow for accessibility are 100% allowable out of an ABLE account. You can also use it for employment training programs, anything that's going to help an individual with a disability become more employable, whether that's a certificate course for heating and air conditioning or a resume writing class. You can use ABLE accounts to pay for assistive technology, an iPad, an e-reader. They actually used in the legislation, they used the example of kids with autism who use their iPhones to help with scheduling and navigation and to make sure they're taking their meds at the proper times. It's a perfect example of one thing where you could use assistive technology to assist in the care of an individual with disability. You can also pay for personal support services. So if you have to hire someone to come into the home to help with the activities of everyday living, cooking, cleaning, bathing, whatever that is, you can pay for those services out of an ABLE account. If you need to pay for the services of an attorney or a CPA or any other professional to help with the management of a disability, you can pay for those funds out of an ABLE account. And you can pay for the end of life expenses out of an ABLE account, whether that's cremation or funeral expenses. They no longer have to be prepaid. Distributions for non-qualified expenses are subject to tax consequences and may impact eligibility for federal or state programs. What does that mean? That means don't use this for things that are not disability related. If it's on this list, you will be perfectly okay using the ABLE account for that. So I'm going to stop my presentation real quick and I'm going to answer some of the questions that we get about QDE. The first one that I typically get is, can we go to Disney World? Can we take a trip? The answer is yes, because a flight or a boat or anything like that is transportation, and that is a 100% allowable expense. Can we pay for a hotel? The answer is yes, that's housing. So if you're paying for the expenses for a disabled person, you can use your ABLE account to pay for those things. The other question we get is, can we use this to pay for groceries? The answer is absolutely yes. You can pay for the activities of everyday living and the expenses of everyday living out of your ABLE account. Okay, let's move on. A couple of examples of things we probably would think you don't want to use your ABLE account for. Don't use them for things like lottery tickets or trips to the casino or alcohol and tobacco products. I'm not saying don't buy those things. What I'm saying is don't use your ABLE account to pay for those things. The IRS may determine that those are not, in fact, disability-related expenses. If it falls neatly onto one of those categories on the slide, you will be okay with the IRS. Let's talk a little bit about what Michigan has done to make this program great for Michigan residents. Number one, they created an income tax deduction for anyone who makes a contribution to an ABLE account. An individual can claim up to a $5,000 income tax deduction on their Michigan income tax return. A joint husband and wife can claim up to a $10,000 income deduction on their Michigan income tax return. Again, this is a Michigan income tax return, not a federal income tax return. There's no 529 deduction on the Fed. Michigan also increased its 529 limit to one of the highest in the nation. It's now $500,000. Theoretically, you could shelter $500,000 in an ABLE account and still remain Medicaid eligible. Michigan offers 5 different investment options. They range in cost and risk. We have an option that's 100% very aggressive in the stock market, and we also have some very conservative, only 20% in the stock market investment options. All of our investment costs are under 1%. We have a program management fee that's 0.5% and a $45 annual fee. All of our fees are taken quarterly, and they're taken out of the deposits into your account, so I'm not going to send you an invoice or a bill every quarter. We also allow individuals to change investment options twice per calendar year, and moving money from an investment account into a cash account for distribution is not an investment change. I mentioned the cash account for distribution. It is FDIC insured, a money market option, and it does come optionally with a debit card so that you can make purchases anywhere that Visa is accepted, and it's very easy to use, just like any other debit card. For those families that have an investment advisor, we do allow investment advisors to enroll in our program. If you want to choose different investment options other than the 5 that we offer, if you want to invest in green companies, or if you want to invest in Michigan companies or minority owned companies, any of those different types of investment options, you can enroll your investment counselor into our program, and he or she can make those investment decisions under the umbrella of the 529 ABLE program. Go ahead. I want to talk a little bit about customer service. I already gave the phone number earlier. It's 844-656-7225. They are there to help individuals navigate our system, to help them make contributions, to help them make withdrawals. They cannot give investment advice, so they will not tell you where you should put your investment dollars, but they are there to help ensure that you can do the transactions that you need. Our website is available for more information and to enroll. We're going to step in now. Having Lisa go first was great because I learned a lot about special needs trust that I don't know. I am an ABLE expert. I know a little bit about special needs trusts, but we are not touting an ABLE account as a replacement for a special needs trust because, as Lisa mentioned, special needs trusts do have their space. I cannot help you with more than $15,000 a year. I cannot help you with things like property. I cannot help you with, taxes and homes, things of that nature. You need a trust to do that. There are some benefits to a special needs trust. They are cost effective. As I said, they're under $50 a year. You have broader spending power. You can use it for things like housing and transportation. There's easy online account access and a state tax deduction for anyone who makes a contribution to an ABLE account. You don't have to worry about filing any federal or state income tax returns on an ABLE account. And the nice thing, and the thing that we're really touting as important to ABLE accounts, is they can be established, administered, and owned by the individual with a disability. As I mentioned earlier, this population has been unable, for the most part, to become economically self-sufficient because they were limited to $2,000 in assets. Well, here's a place where they can start their journey into economic self-sufficiency. I'm going to talk now a little bit about the ABLE website, just so that you can see them if you have clients and or family members who want to learn how to navigate the system. Once again, our website is www.myable.org. If you're ready to open an account, and I'm going to go really quickly, just talk about some of the tabs. Across the top, it says Why MyABLE, so you can actually look at some of the benefits to opening an ABLE account. Account holders has our information on our prospectuses for the various different investments. Give a gift, I'm going to talk about it in a second, and contact us gets you in touch with our customer service team. If you're ready to open an account, all you have to do is click on Open an Account. And I'm going to go through these slides relatively quickly, simply because this is an investment account that you're opening with the state of Michigan. So we're going to need a lot of demographic information. We're going to need names, addresses, dates of birth, social security numbers, all the information that you would need to open a bank account or any other type of investment account, whether that's with, Fidelity or any other type of investment company, we're going to need to open an ABLE account as well. The record so far is about 10 to 15 minutes to actually open and fund an account, so it's not complex, but there is a lot of information that's requested. The first thing that we ask you to do is create a username and password. That just makes it easy. Excuse me, I apologize, I jumped ahead. First thing we do is we take an eligibility quiz. We want to make sure you're in fact eligible to open an ABLE account. So we ask questions: are you opening the account for yourself or for a family member? Are you eligible for SSI or SSDI? Did you have a disability before age 26? Things of that nature. If you are in fact eligible, the first thing we ask is for you to establish a username and password. That way you can step through the process, and if you're 3 steps in, you can just come back to it without having to start over from the beginning. Then we will ask for electronic delivery of documents. Let's face it, it's 2021. Most people get their bank and financial statements electronically as opposed to through the snail mail. We do have the ability to add an authorized signer. So if you have both mom and dad who want access to account, or you have multiple individuals, be it siblings, or you want a spouse and a sibling to have access to the account, you have the ability to add an authorized signer. Next thing we have you do is look at our investment allocations. As I mentioned, we have 5 different investment options. You do not have to choose just one. You can allocate your money any way you want. You can put your money into the most aggressive fund and the least aggressive fund. And you can also put money into the money market account as well. So there's no limits as to how you allocate your funds. Once again, you can move your deposited money twice per calendar year. Question from Jean says, when an individual receives SSI, would my ABLE be concerned about where the money for the ABLE account is coming from? Let's say a person starts their ABLE account with $3,000. Absolutely not. No, you don't have to worry about where the money is coming from, because remember, we allow gifts. We allow individuals to fund ABLE accounts through the gifting portal, which I'm going to talk about in a second. So that's a great segue, Gene. I appreciate that. But for instance, we actually had people who wrote a check the very first day that we opened and funded accounts up to the annual contribution limit, which at the time was $14,000. So no, again, because we allow both money from the individual with the disability and from family and from complete strangers, there's no reason to be concerned about where the money is coming from. So Gene brought up an interesting segue because Michigan has created a really cool donation profile that allows individuals to put their information out there, completely optional, to solicit a crowdfunding aspect of your ABLE account. So if you go to Give a Gift, it will pull up individuals who have volunteered to put a name and a picture out there to tell their story, to say, I'm saving for a wheelchair accessible vehicle. I'm saving for a trip to a camp. Any one of those stories can be told. And it's really easy to do. Once you find the person, you can type in their name and you can search for a donation profile. For those of you that are computer savvy, you can make a donation right online. For those of you who have family members who still want to mail a check, you can click on where it says get a coupon and they can print out a coupon to mail a check to our trustee. Nancy asks, so SSDI money can be put into an ABLE account? The answer to that is absolutely yes. SSDI money can be put into an ABLE account. SSI and SSDI will not make a direct deposit into an ABLE account. The money has to go from SSI to a financial institution, but then we can link your financial institution into the ABLE account so that you can make that transition seamlessly from SSI to your financial institution and from your financial institution into a ABLE account. How does the Michigan limit of $500,000 affect the individual's eligibility for SSI or RSDI? Once again, the SSI limit for ABLE accounts is $100,000. It's at that point that SSI benefits are paused, okay? So yes, if you have $500,000 in your Michigan ABLE account, you will not be receiving those SSI benefit checks on a monthly basis any longer. And If that's something, if that's a source of income that you do not want to give up, then at that point, what you can do is start using the ABLE account and paying that money down. Okay, I think I have one more slide. Okay, questions and answers. So if anybody has any questions, you can either go off mute or you can type it in the chat. While I'm waiting for that, I do want to mention, thank you, perfect opportunity. The MyAble outreach is continuing and ongoing. I gave you my email earlier. If you know of any other events where MyAble would be a good topic of discussion, please feel free to email me, because I'm always looking for other people, other events, and other organizations to talk MyAble at. So with that, I'm going to turn it back over to Vicki unless I see any other messages. And I appreciate very much your time and attendance. And I thank Lisa and Vicki and Mary for having me. And I appreciate very much the chance to talk ABLE. Thank you.
Thank you, Scott. That was excellent. Excellent information. And I'm feeling Mary will probably keep you busy.
Good.
I do try.
Good. Any additional comments or questions before we do our closing information? All right. Well, again, thank you everybody for attending our training today. Spectacular information, so useful information. I learned a ton. I have a family member who has a disability, and this is one of the areas that I really needed to have some better understanding about, so it was excellent.
Hello.
A reminder, Josie, go ahead.
Regarding the ABLE account, which I was able to open for my daughter, I have a question regarding funeral plans. I've heard from one attorney that it has to be prepaid. I have heard it from my private attorney that it doesn't have to be prepaid. Now I'm hearing from Scott that you do not have to have a funeral plan prepaid. Can I please get some assurance regarding that matter?
Absolutely. And I'll tell you what, if you send me an email to my email address, myable@michigan.gov, I can send you the relevant IRS ruling on the fact that it does not have to be prepaid, so that you can take it to your attorney or whoever, anybody else. But yeah, I can send you that.
Yeah, I have an updated IRS ruling. It's just, I got confused. My private attorney said that, yes, you do not have to have it prepaid. Then I have a different attorney who said, no, all funeral plans has to be prepaid. So that's why I asked questions.
Nope. I'll be happy to be the deciding vote. And no, it does not have to be prepaid. And I will send you the relevant statute.
But it does not have to be prepaid, you said?
It does not have to be prepaid. You are correct.
Okay, can you please give me your email again, Scott?
Yes,
please?
it's miable@michigan.gov, G-O-V.
Mm-hmm.
All right.
Yeah, I just ABLE account for my daughter. Thank you so much, Scott.
You're welcome. Thank you for being an ABLE participant.
Good question, Josie. Thank you. All right. So if you want social work CEUs, remember that you have to complete the survey, and Caitlin is going to put the link of the survey in the chat. If you want right CEUs, you can email Jean Fettner, and her email address is also in the chat. For those of you that work in the recipient rights area, CEUs are available. All right, next slide. So we do have some upcoming sessions. Again, this session we're going to be doing again at 6 o'clock. So if you know someone who wants to participate and missed it, have them email me. I'm happy to send the link to whoever wants to participate. So our next session in June will be about identifying circles of support. That we're going to use the life course tools as a basis for that conversation. July will then also be about supported decision making, using life course tools related to supported decision making. Then we're going to talk about assistive technology in August. September will be about healthy relationships for people with disabilities. Sometimes we forget that we all want to have caring, loving relationships with all kinds of different people in our lives. And so that's a really good topic as well. And then in October, really, how can peer services help related to supported decision making and supporting as one of the tools as part of supported decision making and supporting the individual to live the most independent life as possible. Somebody is asking, are you going to continue social work CEUs? We are going to try. It takes a little bit of effort to get those approved. So we're working, doing our best. If we can get all the information gathered that we need for those, I am trying to get those for each month. ORR or rights CEUs, I believe this is the last month for those. The other ones do not qualify. Jean, if I'm incorrect, you can correct me, but I believe that's what I had read previously.
That is correct, Vicki.
Thank you, Jean. So again, we've got these other great topics coming up. Please spread the word. We want everybody who would like the information to be able to join us. And then let's see our next slide. Where to find the recording. So if you go to our website at oaklandchn.org and you click on training and you scroll, you click on training, then you click on provider training, and then you'll scroll down to supported decision making series, and all of the recordings are there. Caitlin also has put the link in the chat. And if you want copies of today's PowerPoint, there's 2 of them. If you contact Caitlin or put your email in the chat, we'll be sure that you get those, because there was lots of information. Next slide. There we go. That's it. Thank you for attending. Really appreciate it. We're just on time. That was packed full of information. I really appreciate our presenters. It was fabulous information. Mary, any closing words?
No, just want to thank everybody for attending, and so grateful for the collaboration with you and with Detroit Wayne Integrated Health. I really appreciate being able to work with different entities around the state to get information out to people.
I do see someone has their hand up, but I can't see who the person is. My team's not working quite right today. Somebody have their hand up?
I believe that was the individual with the question about that was already answered.
Okay, great. Thank you. All right. Thank you so much. Have a wonderful Tuesday. Again, excellent presentation, Lisa and Scott. Thank you so much.
Thank you very much.
All right. Take care.
Thank you.
Thank you.